Data Use and Considerations under the Future Act and FAFSA Simplification Act. Featuring Michael Ruglas, Program Specialist, Policy Implementation and Oversight.
My name is Mike Ruglas, and today we're going to be talking about what it means to use FAFSA data specifically in a new term, federal tax information, and what that means under the Future Act and FAFSA Simplification Act. So let's dive in. So on our agenda today, we have we'll start off with some definitions and notes, go over some key terms and phrases just so we're on the same page before we get going. We'll kick it off with Section 483A3E. Many of us in the financial aid community are familiar with this provision and how it relates to FAFSA data use restrictions. We'll talk about changes to FAFSA data use and how this is under current 23-24 and prior, and then moving into 24-25 with FAFSA and FTI data use, specifically as it relates to the Internal Revenue Code and changes under the Higher Education Act. We'll also talk about the intersection of FERPA, or the Family Educational Rights and Privacy Act, and how that relates to the Internal Revenue Code, specifically to as it pertains to the access, use, and disclosure of FTI. Then we'll talk about the application, how this can be looked at through the lens of some use cases and what permitted and prohibited uses are. And then we'll round things out with some frequently asked questions that we received over the last several months during some of our webinar series on the FAFSA and FTI data use. And then we'll conclude with some key points and resources today. So like I said, some definitions and notes. This first one is relatively new. We're talking about FTI, or federal tax information. We introduced this term this summer in our May 12th, 2023 electronic announcement, where we introduced this particular topic. And this means information or tax return information that is received from the department by the Internal Revenue Service, or the IRS, under our Future Act matching program, commonly referred to as FADDX. Institution of higher education means a post-secondary education institution that participates in Title IV programs. And then we'll refer to our partners that are state higher education agencies as those agencies that are authorized to administer state-based financial aid programs. And just a quick note here, again, we're introducing this topic as it relates to changes to FAFSA data. For so long, we have been used to the phrase of FAFSA data, including all information on the FAFSA form itself. But this obviously is changing with the Future Act and the FAFSA Simplification Act as this is implemented and goes live for the 24-25 FAFSA cycle. And so we're going to be answering questions related to the access, disclosure, and use of FAFSA data and FTI, and how this data can be used internally and externally to our institution and state higher education agency partners. I want to make a note here, another note, or just underscore the importance of now the differentiation between FAFSA and FTI data as we talk about this in the context of moving forward in 24-25. So as I mentioned when we kicked things off, Section 483A3E of the Higher Education Act specifically outlines the data use restrictions. And for so long, we have been commonly attuned to the phrase, that the information on the form shall only be used for the application, award, and administration of aid awarded underneath this title for state aid awarded by eligible institutions or entities that the Secretary of Education may designate. Now, if you've looked at any of the statutes or the amendments under the FAFSA simplification, you'll note that the application, award, and administration of aid hasn't really necessarily gone away, but how it is used and then how it is applied going forward does change. And so that's what we're also going to be touching on here today. But to set the stage as we move forward, this is current statutory interpretation for Section 483 and the use of FAFSA data for 23-24 in years before. So what are the impacts of 483A3E, right? Again, as I said, this is 23-24 and preceding FAFSA cycles. And so this is information that the applicant or the student and their contributor, their parent or parents and spouse would have provided information on the FAFSA. This would have been PII, demographic information, income and assets. And this also includes information that's received via the IRS data retrieval tool. Now, again, we'll probably dive into this a little bit more, but there's a distinction in the data and how it's retrieved and sent to the department today under 23-24 and how that will change in 24-25 that changes the categorization of that data from FAFSA data to FTI data. So for purposes of today, for 23-24, that income and asset information received via the IRS data retrieval tool is still considered FAFSA data. And that's also including student eligibility information, list of colleges that will be receiving the data. And this also extends to derived FAFSA data, right? So the expected family contribution and federal Pell Grant eligibility, yes or no. So that's been the impacts thus far. We recognize that we can't necessarily capture all of the impacts across the board here, but these are the provisions here of what FAFSA data includes, and how that data is utilized is quite extensive. So in this slide, we're going to be talking about changes to FAFSA data use as it pertains to the 24-25 FAFSA cycle and succeeding FAFSA cycles. So for those taking notes or looking at this particular presentation, following along, please tune into this particular slide as there's very important information here. Right off the bat, FTI data includes any federal return information that the department receives from the IRS under the Future Act matching program. This includes tax filing status as a yes/no, right? Again, as I mentioned previously, under the IRS data retrieval tool, this could be treated as FAFSA data, but now this is most restricted under the Internal Revenue Code, specifically Section 6103. And so, FTI data is no longer FAFSA data. Again, let me repeat, starting in 24-25 and succeeding FAFSA cycles, FAFSA data no longer includes FTI data or income information that is received by the department from the IRS. So what does FAFSA data include? This includes applicant and contributor information provided on the FAFSA, similar to preceding FAFSA cycles. This also includes manually entered or provided income and asset information. And we highlighted this in bold to make the distinction. So if it's not received via the Future Act matching program, but rather an applicant or a contributor provides this information on the FAFSA form, this is considered FAFSA data. And then, of course, derived FAFSA data will include the new SAI, the Student Aid Indexed, and the Federal Pell Grant Eligibility Indicator is yes or no. So again, I just want to reiterate and underscore this again, that beginning with the 24-25 FAFSA cycle, FTI received on the ICER is not considered FAFSA data and should be treated in a much more restrictive manner, and we'll go through those components here in a little bit. So what this means is that the access, use, and disclosure are implicated under the Internal Revenue Code 6103 L13, and they are further restricted under the Higher Education Act of Section 483 and 494. Again, we've primarily been used to HIA Section 483 A3E, but now there's two other components, the Internal Revenue Code of 6103 and Section 494A. That are now implicated. And so to take this a little bit further, in addition to Section 483A3E, Section 485B, which is primarily related to NSLDS, the National Student Loan Data System, and as well as the Privacy Act, and as well as FERPA, these were the three primary lenses that the department and what we encouraged our partners to utilize in determining whether the access, use, and disclosure of FAFSA data was permitted. And so if we look at this in an application setting and a use case, is that for 23-24 and preceding FAFSA cycles, institutions, state agency partners as it relates to access, use, and disclosure of FAFSA data need to look at whether or not that's permitted through these 3 statutes, right? And again, as I continue to reiterate over and over, this is now expanded, right? So now we have an amended version of Section 483 with new provisions. We'll go over that here in a little bit. 45B was untouched as it relates to data use. And now we have Section 494 of the Higher Education Act, which specifically details the consent and the authorization to further redisclose FAFSA data. And in addition, we have the Internal Revenue Code, the IRC 6103 L13 as the other statute that an institution or the department we look at as it pertains to questions that we may get from the community around permitted or prohibited uses and disclosures of federal tax information as well as FAFSA data. So let's dive into what these changes are, right? So let's kick this off with FTI data disclosure laws that are implicated under 26 USC 6103 L13. And what this primarily does is it permits the disclosure of federal tax information with the approval of an individual for purposes of applications or recertifications of income contingent or income-based repayment, discharge of a loan based on total and permanent disability, and what most are interested in this for this particular presentation, especially because so many of our partners receive FAFSA data via the ICER, is the implications around federal student financial aid. And so as it pertains to this, the Internal Revenue Code states that the FTI data that is provided to the department and further redisclosed to colleges and universities, as well as state higher education agencies, it may only be used for the purpose and the extent necessary in determining the eligibility for and the amount of federal student financial aid under a program authorized by the Higher Education Act, and you'll see that citation there. So there are additional uses of the disclosed information. The redisclosed 6103 L13D permits redisclosures to institutions of higher education, state higher education agencies, and designated scholarship organizations. And again, you'll see the application, award, and administration of aid component here in the statute. What it underscores is that the FTI that is sent and further redisclosed to these partners can only solely be used in the application, award, of administration of financial aid awarded by the federal government or by one of these entities. There's no other provision that permits the use of FTI for other purposes, and we'll explain that a little bit further. There are 2 scholarship organizations designated that were designated by the department prior to the enactment of the Future Act that meet the statutory definition and therefore eligible to receive FAFSA data, including FTI. This is the United Negro College Fund, UNCF, and the Hispanic Scholarship Fund, HSF. And then the other component of 6103 L13D permits further redisclosure of FTI to contractors. We recognize that many of our institutions and state higher education agencies will contract with third-party servicers to carry out certain functions of the application, award, and administration of financial aid programs. And so there is a component in there that permits this disclosure from an institution to a contractor to assist the institution in the efforts of awarding and applying in the administration of financial aid programs. So stepping away from the Internal Revenue Code amendments from the Future Act, the other component that is relevant to this presentation from the Future Act is 20 USC 1098H, or Section 494A of the Higher Education Act. And what this did under the first element is it provided a notification and approval requirement from the applicant or the contributor for federal student financial aid purposes, again for TPD and income-based repayment programs. Again, a requirement that the department has to obtain approval and also has to provide notification of when FTI is matched with an individual and used for purposes of determining aid eligibility and the amount of aid. So continuing on here, procedures for requesting FTI under Section 494A of the Higher Education Act also discusses access to FAFSA information. So again, if you're following along, paying close attention, this is a particular slide that you'll want to make note of because this discusses the instances where FTI information can be accessed and the further and what is permitted for further redisclosure purposes. And we'll dive into that here in a little bit. But there are three main components of this part of the statute. There's the redisclosure part, the discussion part, and the restriction component of FAFSA and FTI information that an institution or a state higher education agency receives from the department. So as it pertains to the redisclosure of information, this is a lot of information on this particular slide, but the information in a complete unredacted student aid report with respect to an application may be provided to an applicant for federal student aid upon request for such information by an applicant. And so if a student comes into the office and requests the financial aid office, that is, and requests to see their FAFSA information or the information used to determine their eligibility, an institution is permitted to provide them a copy of their the statute says student aid report. We recognize that is now the FAFSA submission summary. Admittedly, the FAFSA submission summary does not have FTI on it, so the institution is permitted to disclose the ICER data that was sent to them, to the student, so that they may be able to inspect that information and ask any questions or what have you, or to use that information to provide it to somebody else. But again, if they request to see that information, the institution or the state higher education agency is permitted to redisclose it in that instance. You'll note the second bullet there is rather, again, lengthy, but this is a very important component and is the basis for a lot of our FAQs and the further redisclosure of data. So with written consent by the applicant to an institution, that institution may further redisclose it to a scholarship granting organization or to an organization that is assisting the applicant in applying for and receiving federal, state, local, or tribal assistance that is designated by them to assist them in applying for and receiving financial assistance for their components of their cost of attendance at that school. Again, I'm reemphasizing the last part of that bullet, right? So the redisclosure of FTI in this instance is permitted so long as that it is helping the applicant in applying for and receiving assistance towards their cost of attendance, right? So this is an important distinction, right? You can't, there's not a written consent that can be obtained to just further redisclose FTI for whatever purpose. Now, if the student comes in again to the first bullet and requests that information and you provide it to them, then they can do whatever they want with that information at that particular point in time. But as it pertains to the institution wanting to further redisclose that, it has to be consistent with 1098H(c)(1), Section 494A of the provision outlined here in this second bullet. So as it relates to the discussion of information, so another part of Section 494A permits an institution with written consent of the applicant to include an individual selected by an applicant, such as an advisor, to participate in discussions that include FTI. It's important to note that, again, sort of changing the practice of how this has been done in the past, we just can't treat this as FAFSA data. This is FTI data that has criminal and civil liabilities associated with it. And so there needs to be complete transparency about when this data is able to be redisclosed, discussed with other people, and it may be discussed with others, with the other individual present in that instance, as long as written consent is obtained. And so, as I mentioned, the other third component of 494A is a restriction on disclosing information. So any eligible entity that receives data with a written consent, FTI data with a written consent of the applicant, cannot further redisclose or use that information in any capacity without the express written consent by the applicant. And so it has to be very transparent to the applicant that if that data is going to be used for some other purpose consistent with the access disclosure that we just talked about a couple slides ago for applying and receiving assistance towards COA, that they have written consent from the applicant. All right, so the last component here of the Future Act relates to Section 494A. Much of what we've been discussing here is around what is required with written consent, right? We've talked about when written consent is required, when it's not required. And in this context, again, hear me out. In this context, written consent here is when a further redisclosure of FTI or FAFSA data is required by the institution or the state higher education agency. This is not talking about the consent requirement that is built into the FAFSA form that an applicant or contributor is required to provide in order to have their aid eligibility determined. This written consent is specific to our partners. So again, highlighting that you'll need to make note of this, that when obtaining written consent, this means a separate written document that is signed and dated, which may be done by electronic format, by an applicant, which indicates the information being disclosed, includes return information, states the purpose for which the information is being disclosed, and states that the information may only be used for specific purposes and no other purposes. And these three provisions here, or the three requirements of the written consent, are found in 494A. We haven't modified them. This isn't some sort of interpretation. This is what is required in the law, that institutions or state higher education agencies must obtain if obtaining written consent for the further redisclosure or an individual participating in a discussion that includes FTI information. So important distinction there, important note to make and take back with you to develop this and look to developing a written consent form that meets these obligations here. So now we're going to move into FAFSA Simplification Act and what amendments were made to the Higher Education Act that impact or affect the FAFSA and FTI data use conversation, right? So there are some here that are very well noteworthy. Section 483 was replaced in its entirety, and so there's an entirely new type of provisions that sort of dictate the redisclosure of FAFSA data as it pertains to states and institutions. And so let's kick it off here, going in order under 20 U.S.C. 1090 483B. So Section 483A3B, the information that is provided to the state in an ISER, there is a permitted redisclosure with authorization from the applicant that we obtain on the FAFSA form to a state higher education agency that is administering a state-based financial aid program, serves as the applicant's state of residence, and this information from the FAFSA, including FTI, may be used for the application, award, administration of grants or other student financial aid provided directly from the state that is determined by such a state. So that's a new component there. There are some other components here that are, again, noteworthy in 483A3B as it pertains to state agency use of FAFSA data. So you'll note there, going from left to right, that a state agency shall use FAFSA information. Again, here we go. This this popular phrase that we've been so accustomed to, shall use it solely for the application, award, and administration of state-based financial aid for which the applicant is eligible, right? So there's the component that is going to dictate the use of FAFSA data and what it may be used for. There is also what is relatively new here is the ability for state agency research, with the exception of FTI. Again, with the exception of FTI cannot be used for research in this context. State agency partners are able to conduct research so long as it does not release personally identifiable information, PII, on any applicant to promote college attendance, persistence, and completion. So again, there's a provision now in the statute that authorizes and permits research with FAFSA data, so long as it doesn't release PII, to promote college attendance, persistence, and completion. So there's that new component there. There's also now a component that allows state agencies to use identifying information that is provided by the student applicants on the FAFSA to determine whether or not a graduating high school student has filed the application in coordination with LEAs and secondary schools to encourage FAFSA completion. Much of this provision was built upon the FAFSA completion initiative, which most of us are aware of and have been engaged in quite some time. But this just further codifies that ability for state higher education agencies to help coordinate those efforts at the state and local level. And lastly, state higher education agencies may share the application information, excluding FTI, with any other entity only if such applicant provides explicit written consent, and except in the subclause 3 that you'll see there, written consent is not required to disclose FAFSA completion status information to LEAs or secondary schools. But in other instances where disclosures may be desired to other entities, other state partners, that the state higher education agency would have to obtain written consent in that situation. So moving on, now talking about our IHE, our institution partners, there are 3 provisions that dictate the use of information provided to the institution. Institutions, similarly to states, shall use the information provided to it solely for the application, award, and administration of financial aid to the applicant. Institutions, like states, may use FAFSA data, again, excluding FTI, that does not release any PII to promote college attendance, persistence, and completion. So there is a research provision in there that institutions may conduct these types of research efforts, these research programs, using FAFSA data, but not FTI data. And last but not least, the institution shall not share such education record with information with any other entity without the express written consent of the applicant. So in instances where disclosure to another entity is desired for other purposes, again, we're only talking about FAFSA data in this context. The institution must obtain written consent of the applicant for that disclosure if it's not for purposes of research or the application, award, and administration of financial aid programs. So let's start to wrap this up a bit related to the FAFSA simplification amendments. So there is a prohibition under Section 483 that any entity that receives applicant information shall not sell, share, or otherwise use that applicant information for any other purposes other than what it was provided to for the institution or the state higher education agency. There's also a further redisclosure limitation of FAFSA information that includes return information, FTI, and applicants' FAFSA information that includes FTI may be disclosed or redisclosed, which includes obtaining, sharing, or discussing such FTI only in accordance with the provisions of 20 U.S.C. 1098. That's Section 494A. Again, you'll want to write that down, keep that in the back of, keep that as a note. 20 U.S.C. 1098 Section 494A specifically outlines those procedures and what is permitted for the access, use, and disclosure of FTI. So let's start to wrap this up. We've talked about the Future Act. We've talked about FAFSA Simplification Act. So let's also talk about the intersection of FERPA and the Internal Revenue Code, right? Both statutes have specific requirements around what is permitted access, use, and disclosure of FTI under the Internal Revenue Code, and FERPA generally implicates student records and when written consent is needed for the disclosure of those student records. So let's dive into this, right? So under FERPA, FERPA protects the PII from education records from unauthorized disclosure. There are requirements when written consent is needed before sharing PII unless an exception applies, like a financial aid or a school official exception. So under these financial aid exceptions, institutions may disclose without prior written consent PII from student education records in connection with financial aid for which a student has applied or which a student has received only under certain circumstances, that is, determining eligibility, awards, conditions, or enforcement of those conditions of the awards, right? So that's FERPA. But under the Internal Revenue Code, this protects federal tax return information, or what we call FTI, from IRS tax records from unauthorized disclosure and inspection or viewing of that record information. There are permitted limited disclosures and uses of FTI, but it's only what is specifically outlined in the Internal Revenue Code and the Higher Education Act. So how do these two statutes sort of fit together, right? Well, as we've talked before and as we've talked in years past, the most restrictive statute applies when looking at both of these. The Internal Revenue Code is the most restrictive statute as it relates to FTI and return information that the department receives from the IRS and further rediscloses to our partners. And so even though FERPA exceptions and written consents are there and permitted in certain instances, they don't apply when we talk about the redisclosure of records that contain FTI, because the FTI is, again, most restrictive under the Internal Revenue Code, and the Internal Revenue Code sets what standards that information may be further redisclosed, and the access of that information and the further redisclosure of that information is further expressed in Section 494A of the Higher Education Act, which was what we talked about. So in practice, right, just because one obtains FERPA written consent, that consent is not applicable to the disclosure of FTI information, because it may only be FTI information may only be disclosed for purposes that are outlined in the Internal Revenue Code and the Higher Education Act. So again, two types of situations. Try not to conflate the two. When looking at a record that contains FTI, you have to look at what are the provisions that regulate and dictate that disclosure of data under the IRC and the Higher Education Act. So again, let me just reiterate, even with written consent, records that contain FTI may be only accessed, disclosed, or used for purposes consistent to the Internal Revenue Code 6103 L13 and the Higher Education Act under 1098H or 494A. So let's look to apply these, right? So what is permitted, what is not permitted? So permitted access, disclosure, and use of FAFSA data on the left-hand side of the slide here, the application, award, and administration of student financial aid programs, right? FAFSA data may be used for research so long as it doesn't release PII on an applicant to promote college attendance, persistence, and completion. And disclosure to external to the institution or agency requires written consent. Now, what is permitted access, disclosure, and use of FTI? FTI may be accessed and used for the application, award, and administration of student financial aid programs, federal, state, institutional. Disclosure is permitted to other entities as defined by the student, but only for purposes in applying for and receiving federal, state, local, or tribal assistance that is towards these students' total cost of attendance at that particular school. and disclosure is permitted directly to the applicant upon their request. All right. So again, disclosure may be given, FTI data may be given to the student upon their request. So this is a slide that you'll want to notate. The difference now, again, we used to talk about FAFSA data collectively. That would include return information for 23-24 years prior, but beginning in 24-25 and the years that follow, you'll have to look at whether it's FAFSA data, whether it's FTI data. So to take this a step further, there are prohibited access and disclosure and uses of FTI data. So applicant and contributor level FTI data, primary level data that includes, their name, date of birth, SSN, that ties the FTI to them cannot be accessed, redisclosed, or used for purposes other than the application, award, and administration of student financial aid programs. This means that it is prohibited to use FTI for purposes of research or other programs or other efforts that are not authorized under the Internal Revenue Code and further restricted under Section 494A of the Higher Education Act. Again, an important note to make with this change as we move into 24-25. So let's start to wrap this up. So we've talked about the implications, the applications, what's permitted, what's prohibited, right? We've talked about the changes under the Future Act and FAFSA Simplification Act, and how that's going to change the implication, the use and access disclosure of FTI starting in 24-25. So as I mentioned when we kicked off this presentation, we had several questions over the last few months around FAFSA and FTI data use, and admittedly, this is new territory for a lot of us, right? And so we've gone through, picked out some of the more frequent questions, and we're going to go through some of those to help sort of set the stage for our partners as we start to look forward to receiving FTI and then access, using, and disclosing this information. So let's kick into some of these FAQs. So our first question here that we got quite a bit: are institutions permitted to disclose FTI data to other departments or offices on campus, for example, an academic department or Office of Institutional Research? And what about FAFSA data that doesn't include FTI data, right? So if a FAFSA record includes FTI data, the disclosure depends. That disclosure must be related solely to the application, award, and administration of federal, state, and institutional financial aid programs. If the use, access, or disclosure is for another purpose, it is prohibited under the Internal Revenue Code. Even with written consent of the applicant, FTI data may only be disclosed or used to assist the applicant applying for and receiving aid towards cost of attendance, or to permit another party to participate in discussions that include FTI data. So the latter part of, or the second question here is, what about FAFSA data, other FAFSA data that doesn't include FTI? So this may be disclosed and used by other internal institutional offices consistent with Section 483 of HIA that permits the use and disclosure for purpose of like research or something to that extent. But the disclosure must meet a FERPA exception in order to be further redisclosed without FERPA consent of the student. So an important note to make there. So as it relates to FAFSA data that does not include FTI, again, I want to underscore this importance here because we're talking about an instance of disclosure and use by other offices that FAFSA data that does not include FTI. So this disclosure may occur when we're talking about the application, award, administration of financial aid. It may also include for purposes of research that doesn't release any PII to promote college attendance, persistence, and completion. And that individual or that entity, that office may not share the educational record information with any other entity without the explicit written consent of the applicant. So those are the three components that are going to dictate the disclosure and use of FAFSA data that doesn't include FTI. So on to our next question here. Can our financial aid office share Pell eligibility status with our academic advisors, counselors at the college to identify Pell recipients, refer them to relevant success resources, and support their persistence in completion? So this is, yes, this can be with written consent of the student. FAFSA and derived FAFSA data may be further redisclosed to other campus offices with the written consent of the applicant for purposes such as, but not limited to, student success referrals to support their persistence in completion. The outline disclosure and use of FAFSA data does not meet the permitted use solely for the application award administration of aid to the applicant, which is why the written consent component is needed. So while FERPA permits this disclosure because it would meet an exception, the Higher Education Act is actually the most restrictive here under the new provisions of Section 483 and requires the consent of the student for the disclosure in this particular use case. So our next question here, can FTI data be shared with a contractor, an individual, or an organization that assists in the awarding of institutional aid? The answer is yes. Institutions are permitted to disclose student-level FTI with a contractor to carry out the application, award, and administration of student financial aid programs. This disclosure is permitted under the Internal Revenue Code, and you see the source there. But it's important to note that contractors shall not use nor disclose this FTI for any other purpose other than what it was disclosed for them, disclosed to them in that instance, and that being for the application, award, and administration of those student financial aid programs. Another similar question that we received this past summer is, are institutions permitted to disclose FTI if the student record is a part of an audit? And the answer to this question is yes. Institutions are permitted to disclose student-level FTI if the student record is requested as a part of an annual audit, and this is permitted under the Internal Revenue Code. So our next question that we have here was one that we received quite a bit from our partners over the last several months, and is that it includes whether or not FTI from the FAFSA can be accessed or disclosed to or be used by our TRIO program or our TRIO office. Again, we received quite a few questions, different variations here, but to answer this, it really depends upon the access, use, and disclosure. Again, as you've probably noted throughout much of this presentation, there's different components to how this data, the FTI data, can be used and how it can be accessed and further redisclosed. But general access and use of FTI data under the Internal Revenue Code must be consistent with the application, award, and administration of federal, state, and institutional financial aid programs. And then if the institution is determining student eligibility, and this is a key element to what is permitted and why this depends, if the institution is determining student eligibility for an amount of a TRIO grant, then FTI data may be accessed, disclosed, or used for such purposes. However, the Internal Revenue Code does not contain a provision that would permit FTI to be used generally that would determine student eligibility for TRIO programs. That is, for instance, additional services and resources. As again, it's not a program that's authorized under the Internal Revenue Code. The Internal Revenue Code is very specific in the three components of the student financial aid programs that is permitted to utilize FTI to determine eligibility amounts of aid. And so access to FTI data in this instance is prohibited, again, beyond the scope of the application, award, administration of aid programs. Again, if the financial aid office or the TRIO office is needing to utilize FTI to determine eligibility for a TRIO grant, then this would be permitted. Otherwise, such access and disclosure is not permitted. Again, however, we remind everybody that with written consent of the applicant, a TRIO advisor, for instance, or another TRIO administrator may participate in discussions with a financial aid administrator for purposes of the TRIO program or other components of the student receiving or applying for aid. So moving on to our next question here. Similar to written consent under FERPA, can an institution or a state higher education agency implement written consent requirement that would permit the access, disclosure, and use of FTI for any purpose? Highlighting the ask here is utilizing FTI for any purpose, and no, this would not be okay. So again, remember, further disclosure of FTI that requires written consent to provide that to other entities must be done on a case-by-case basis and consistent with permitted disclosure and uses of the data under the Internal Revenue Code. Again, to say this again, the application, award, and administration of financial aid programs, and more specifically under the Higher Education Act, Section 494. So again, having a written consent requirement that a policy that requires all students to sign it is not permitted. It must be done on a case-by-case basis, and it must meet the requirements under Section 494A, which specify the key components of written consent and what must be included in that written document that is signed by the student. So again, what designated scholarship organizations are eligible to receive FAFSA and FTI data under the Future Act, and can other scholarship organizations be designated? We mentioned this earlier in the presentation. So prior to the enactment of the Future Act, the department had only designated 2 scholarship organizations, so therefore that meet the Future Act definition, that being the United Negro College Fund and the Hispanic College Fund. So again, those are the only 2 that meet the definition and are eligible to receive the FAFSA and FTI data for purposes of administering those scholarship programs. As it pertains to other scholarship organizations being designated, at this time, Congress has not authorized other scholarship organizations to receive FAFSA and FTI data. So those disclosures to those organizations must the institution, for instance, must obtain the written consent of the applicant in order for that disclosure of FAFSA and FTI data to take place. Moving on here, so can an institution use FAFSA information to share more information with them about federally means-tested benefit programs like SNAP, Medicaid, that they might be eligible for? And yes, this can be done, again, with FAFSA information, not FTI, but the institution must obtain the written consent of the applicant and, if applicable, their parent or their spouse to use their FAFSA information to share more information with them about other federally means-tested benefit programs that they might be eligible to receive. Again, even with consent of the applicant, FTI may only be disclosed or used to assist the applicant in applying for and receiving aid towards cost of attendance. So in this instance, even though that they be receiving a federally means-tested benefit program or possibly aiding in determining their eligibility for that program, FTI can't be used in this instance. And our last question that we have here is, can a state higher education agency or an institution of higher education disclose student-level FAFSA data that includes FTI without written consent of the applicant to researchers or research groups for studies related to student completion and success rates? And what about student-level FAFSA data without FTI? So to answer the first question, no. Even with written consent of the applicant, FTI data may only be disclosed or used to assist the applicant in applying for and receiving aid towards cost of attendance. There is also a strict prohibition on the use of FTI for research purposes that is outlined in Section 483. However, FAFSA data that does not include FTI, again, is permitted to be used to promote college attendance, persistence, and completion. May be used in research efforts so long as it does not release personally identifiable information. So again, just highlighting the difference of whether or not FTI and FAFSA data can be used in these instances, and it's an important distinction as we move forward in 24-25. So let's start to wrap things up here. So let's kind of talk about some key points and resources and just some reminders as we start to move forward. Again, acknowledging that we've introduced a lot of new topics, a lot of new definitions, a lot of new use cases and applications as it relates to FAFSA and FTI data. And so we'll try to highlight these and provide some resources as we move forward. So some key points to keep in mind: FTI data that is received by the IRS, again through the FADDX, have access, disclosure, and use restrictions that are implicated under the Internal Revenue Code and Section 494A of the Higher Education Act. There are permitted uses of FAFSA and FTI data. FAFSA data, for instance, can be used for research, whereas FTI data cannot be used for research or redisclosed for research types of efforts and would be a prohibited use of the FTI data. There are implications for third-party servicers and contractors while they're eligible to receive this data if they are contracted with an institution or a state higher education agency by conducting the application, award, and administration of aid programs. They're also have to follow the same safeguarding requirements that are outlined in our May 12th, 2023 electronic announcement related to protecting and using and accessing federal tax information. And again, just underscoring the significant change from FAFSA data generally to now FAFSA and FTI data. And these changes are effective beginning with the 24-25 FAFSA cycle. So when your institution starts receiving ISA records for the 24-25 FAFSA cycle, there is a complete and utter distinction between FAFSA data and FTI data and the use and access and disclosure of that data. And I think this goes without saying. There are significant risks of misusing the FTI data. There are provisions in the Internal Revenue Code that apply to individuals for unauthorized disclosure and inspection of tax return or return information. This includes the information that is provided on an ISER for 24-25 and going forward. There is also a provision of civil liability for knowing or negligent inspection or disclosure of tax return information by an officer and employee that is in violation of provisions of the Internal Revenue Code of 6103. So again, just highlighting the importance of these key components. So to mention a couple different resources here. So again, I've cited it a couple times. We released the May 12th, 2023 electronic announcement, Access and Use of Federal Tax Information for Federal Student Aid Programs beginning with 24-25. That introduces a lot of these key components, the importance of protecting the FTI information that is going to be received by our partners. And then, as we discussed earlier, sort of the intersection between FERPA and the Internal Revenue Code. We included a recent publication from our folks in Ed Privacy from March of this year about eligible student guide to FERPA. So it's another great resource for our partners to look at as well. Again, I understand there's a lot of information. It's very dense, very nuanced, very complex, right? And as always, the department recognizes that there will be significant questions that everybody has, from colleges and universities to our state higher education partners to our research partners and others that relate to FAFSA and FTI data use. And so we'll be releasing additional resources in the coming months to help reiterate much of what was covered in this presentation, provide more FAQs as we get them and as we see that they're applicable to the community as a whole. We definitely want to share that information with you all. So in light of that and in saying that, if you have questions or you have a particular use case that you want to run by us, please do reach out. We again recognize the importance of this. We also want to help in this endeavor to ensure that the FTI and the FAFSA data is protected and redisclosed in manners and used in manners and accessed in manners that are consistent with the Internal Revenue Code, the Higher Education Act, and where applicable, FERPA as well. So if you have questions, go out through Partner Connect, the Help Center Contact Customer Support webpage. Select the topic FSA Ask a Fed /policy, put in your information there, your question. It will get routed to the appropriate subject matter experts to review the question, look at it. Some of these may be able to provide a quick yes, no. Others may be more complex and take some additional time to answer. So we appreciate your understanding in that. So thank you again for listening to me talk for these last several minutes, going over some very important information. I've got my contact information up here for better or for worse. So if you do have questions, comments, concerns, please do feel free to reach out. Thank you again for attending this breakout session, Data Use Consideration under the Future Act and FAFSA Simplification Act, and take care.